Okay, I think it is time. Welcome everyone to our first session of our day-long session of military law training from the Military Law Task Force of the National Lawyers Guild. We're really excited to have you here today. Just want to share a few housekeeping things. First of all, if you have along the way, for those of you watching online, I'll be sharing two numerical codes every hour at random points. Be sure and write those codes down, because when you at the end of this, we'll be sending out an email asking, did you attend? We'll ask you for those codes, and that's something a lot of the state bars require to show that you've attended. Of course, for everyone attending in person, those folks, just be sure and sign in the sign-in sheet, and we have one for every hour. I know it's kind of a pain, but again, to comply with the state bar rules, we have to show who was here for what hour. So that's the first thing. Other thing I'll mention is that when you're not speaking, please keep the mute on to just help manage background noise. We do, on most of these sessions, we're planning some time for Q&A at the end, so we may ask you to unmute at that point. But also, along the way in these presentations, if you see any good questions, go ahead and ask them in the chat. And if there's an opportunity, I may try to get those things addressed along the way. By the way, my name is James Branum. I'm one of our steering committee members, but also the CLE coordinator for the Military Law Task Force, the National Lawyers Guild. And for our first session, let me pull this up real quick. Our speakers today will be Maria Santelli, Deborah Karpatkin, and Peter Goldberger. And just a little bit about each of them. So, for Peter Goldberg, he is a semi-retired attorney based in Ardmore, Pennsylvania, near Philadelphia, whose practice for more than 40 years focused on federal criminal appeals, including Supreme Court petitions and cases. Peter is a former public defender, former law professor, and frequent CLE speaker. He has counseled and represented conscientious objectors and war resistors since volunteering with CCCO at Haverford College during the Vietnam War and working with guild lawyers while a student at Yale Law School in the early 1970s. Among other volunteer and pro bono activities, Peter serves as president of the board of directors of the ACLU of Pennsylvania. Also, Deborah Karpatkin is an attorney in private practice in New York City. She has represented a number of military conscientious objectors and is a frequent contributor to On Watch, on CO law and practice, among other subjects. She is vice president of the National Employment Lawyers Association and a member of the New York City Bar Association, serving previously on its Military Affairs Committee and currently on its Sex and Law Committee. She teaches employment discrimination law at Touro Law School and serves as general counsel to the New York Civil Liberties Union, where she was a board member for 23 years. And finally, we have Maria Santelli. She is a board member and former executive director of the Center on Conscience and War. She has counseled many conscientious objectors who have been successfully discharged from the U.S. military. So for this first session, we are exploring the topic of conscientious objection, an overview of other discharges, some of the related issues that come up, including the issues of litigation. So we're going to start with Maria, focusing on the administrative side of how applicants apply, what that whole process looks like. So I'm going to hand it over to Maria.
Thank you. Good morning.
Morning.
I was told it was necessary. I was brainwashed. As a U.S. Army chaplain, I watched on August 6th as the Enola Gay took off for Hiroshima. On August 9th, when Boxcar took off for Nagasaki, I said nothing. I knew hundreds of thousands of women and children would be vaporized, and I said nothing. I was silent. We, all of us, must no longer be silent. Father George Sadaka, World War II Catholic chaplain and subsequent conscientious objector. I will say here boldly now on television, no. I will not go 10,000 miles from here to help murder and kill another poor people simply to continue the domination of white slave masters over the darker people of the earth. Muhammad Ali, Vietnam era, conscientious objector. Although the information had not yet been published by the WikiLeaks organization, I felt this sense of relief by them having it. I felt I had accomplished something that allowed me to have a clear conscience based upon what I had seen and read about and knew were happening in both Iraq and Afghanistan every day. Private First Class Chelsea Manning, Iraq War whistleblower. I believe that my commitment to love indiscriminately is in contradiction with the effort of war and violence. I believe I am complicit in the conduct of war and the destruction of human life on both sides of the battlefield. Jeff H., 21st century conscientious objector. Conscientious objectors, or COs, start, like all these people did, with what's in front of them, with what they are witnessing, what they are doing, what they are failing to do. They start by recognizing that something is wrong. And this tug on their conscience evolves into a realization that all war is wrong, and that their participation in it is a violation of their most deeply held values and beliefs. As Dale said, I'm Maria Santelli, Executive Director Emerita of the Center on Conscience and War. I served in that position for exactly 13 years. And in that work, I read statements, and the current staff and the past staff have all read statements from conscientious objectors and heard a sense of relief expressed over and over again, even before a person is discharged or any action is taken on their case. Just a simple act of declaring themselves as conscientious objectors, taking that proactive step to reclaim their moral conscience, brings an immediate sense of relief. Yet the process is not an easy one, and by no means is it a speedy one. The right to conscientious objection for members of the U.S. military today is supported by the 1940 draft law, which, thanks in part to the founders of our organization, enshrined in U.S. law enforceable, robust protections for conscientious objectors. And that is the same law, the same legal basis that the Department of Defense bases its policy on today. The founders of CCW, the Center on Conscience and War, CCW, lived through and witnessed the barbaric and shameful treatment endured by World War I conscientious objectors. Composed mainly of the historic peace churches, Quakers, Mennonites, Church of the Brethren, as well as the Methodist Office of World Peace, there was such a thing back then. Our founders had been observing the escalating situation in Europe in the 1930s. By 1940, when it was clear that the U.S. was going to enter into World War II, they worked to make sure that there would be protections in the draft law. In World War I, there were conscientious objectors, but the parameters were very, very narrow. It was very difficult for anyone to meet those parameters. And so, for example, if a man received a draft notice, he was in the military. So if he refused to show up, if he refused to wear the uniform, any of those things, he was tried by military tribunals. The whole time in military custody, tortured. The original waterboarding happened to, U.S. citizens in World War I. Conscientious objectors, mainly men of faith and conscience, or all men of conscience, mainly men of faith. So it was a shameful in several other countries during World War I. Our founder sure that there would be the ability to do civilian-directed community service. You have civilian-directed service. You were still drafted, but you performed civilian-directed service. You didn't have to join the military. You do your drafted service in the military. They made sure that people who refused would be tried by civilian courts and not military tribunals. So there were improvements to the law. It was also that you didn't have to be part of a peace church. In World War I, in order to be a conscientious objector, you had to be a member of a peace church, meaning that they had a statement of peace on their books at the time the 1917 draft law was signed. That was a hard bar to meet. So in World War II, that was eliminated. And the personal, you still had to be religious for a little while until, I'm sure some of you are going to talk about the court cases that opened up the law, but it mattered what your personal beliefs were, not what any particular church teaches. And that is still the policy within the law today. By the 1960s, the DoD had a change in policy, so we still had a draft, but the DoD had realized that people were going to be drafted and were going to become conscientious objectors in the course of their military duty. So since the 1960s, people have been able to apply for discharge once already in the military. as, and get discharged as conscientious objectors once already in the military, and that's still the policy that's in effect today. So when someone like those folks that we just heard from a few moments ago has that tug to their conscience, has that change of heart, and they find themselves in the U.S. military, having been recruited into the U.S. military, what are they facing? So, in a nutshell, how I've talked to people about it over the past 13 years is that you have a legal burden to basically prove three things: that you are opposed to your participation in war in any form. You must prove now in an all-recruited
recording in progress.
You must prove in an all-recruited military today that these beliefs developed after you joined. So that's kind of the difference from the draft. Recruited military. You must prove in an all-recruited military today that these beliefs developed after you joined. So that's kind of the difference from the draft era. In the draft era, you're proving that this is a lifetime commitment to peace and nonviolence. In an all-recruited, or some people call it an all-volunteer force, the burden is to show that your beliefs have changed, that you have had a change, that you felt like your participation in war was acceptable when you joined, you no longer do. And then finally, you have the burden to prove that these beliefs are a controlling force in your life. In other words, these beliefs guide you more strongly than anything else in your life. So how do you do that? Well, I don't give the Department of Defense very much credit, and I don't know that they didn't develop the application actually, right? This came from Selective Service back in the day, but the application is the mechanism by which people most effectively can prove that they meet that legal burden, that they meet that legal standard to be classified as a conscientious objector. And I say classified because most people apply for discharge, but not everyone does. So there is also the option to apply for a non-combat status so that you remain in, your contract, you perform military duties, but they are not combat related. As much as we can decide that the military itself is not all combat related. So through the application process, each branch has a very similar application. There's been some problems with that in recent years where the application has been truncated in some of the branches, but the application essentially, and the one that we urge people to stick with, has several biographical questions, demographic, who you are, where did you go to school, where have you lived, all of that kind of stuff. But then the foundation of the application is the essay portion. There are 6 essay questions that actually, this is where I give the application some credit, that actually lead people to answer and to address those 3 legal burdens. So the questions you're being asked are, what are your beliefs? How did those beliefs develop over time? And what is the evidence of those beliefs in your life? So I just got a text message that someone's waiting in the waiting room. So as someone goes through that application, there's 6 questions, as I mentioned. So question 1 is, what do you believe? That is the foundation of the application. Question 1 is the foundation of the application. If the application is the foundation of the process, question 1 is the foundation of the application, because you are putting forth your moral framework. You're leaving no question, right? You're stating quite clearly that you meet the standard of your beliefs guiding you, that your participation in war is wrong. That's question 1. Questions 2 and 3 walk you through the evolution of your beliefs. So question 2 is asking, how did your beliefs develop over time? So that's literally a timeline of how your beliefs developed over time, how you went from the person who thought your participation in the military was okay to the person you are now who believes your participation in the military is against your most deeply held beliefs. That's question 2. Question 3 is that when. It is literally asking you to place the moment in time at which you knew your beliefs were no longer compatible. For many people, right now, we're talking modern day, That was October 7th, 2023. For a number of other people going back, that was September 11th, 2001, or it was March 20th, 2003, or it was the day that that the U.S. bombed Doctors Without Borders hospital in Kunduz, Afghanistan in 2015, or it was the day that George Floyd was murdered on the street in 2020. It's that literal moment in time when you knew you could no longer in good conscience continue with this process. That's question 3. Questions 4, 5, and 6 are the evidence questions. Now, this is what's problematic about the way the DoD instruction has their application and the Army at this time. They have removed those 3 questions. So if the burden of proof is on the applicant to provide evidence that your beliefs meet the standard to be discharged or classified as a conscientious objector, yet the application has removed your opportunity to provide evidence and you don't have good guidance or counsel, what are the chances that you're going to be successful? So that's a problem. But we urge people to put those 3 questions back in and answer all 6 questions. So question 4 is the use of force. Question 4 is asking you, what is an acceptable use of force? So that's asking people to think deeply about these things. Do you believe that World War II was actually a good war? Do you believe that, the war in Afghanistan was necessary and right? Do you believe that, you can, assume where people might go with this, that terrorists should be stopped, that ISIS should be stopped. So all of those types of things. Do you believe that it is okay to defend yourself on the street if you were to be attacked? We ask people to approach this question in those 2 directions, in a sense of national defense and in a sense of personal defense. And that really helps them dig deeply and really think deeply about these things and really consider. Now, the law says, the Supreme Court says, that you do not have to speak for some hypothetical past or future you. That is true. And if someone were to be badgered in their hearing to speak for some hypothetical situation where aliens invaded planet Earth or something, we would step in and we would say, hey, that's, that's out of bounds. But it's okay to run through. We encourage people to really run through some of these hypotheticals in your head so that you really have a sense of yourself, so that there's no question that you're going to be asked by your chaplain or by your investigating officer that you yourself have not already, mulled over 360 degrees. I ride a bike, so I think of it as a bicycle wheel. 360 degrees around with spokes coming in from all angles. That's our challenge as counselors, is to make sure that they have thought 360 degrees around this issue and where their beliefs are on this issue. So that's question 4, the use of force. Very important question. Questions 5 and 6 are looking for evidence from your life. Question 5 is looking for daily life. So sort of the smaller stuff. Have you changed your diet and become vegetarian or vegan? Do you meditate? Do you pray? Do you attend services? Do you practice yoga? Those types of things. What has your daily life become since your beliefs have changed? And then question 6 is looking for something big, the conspicuous evidence. What is the point greater than anything else that proves that you are a conscientious objector? For many people, that could be they have to pay back education, sometimes to the tune of $400,000. The military prices the academies at $400,000. That's a big price tag. But for most people, the peace of mind, peace of heart is worth that price tag. So that's the application. We encourage people to get letters of support. So not only are you providing evidence, but people are reflecting back what they see in you. Even if someone doesn't agree with you, if it's someone that you currently perform your military duties with, and they've observed this change in you, but they don't agree with you, they can write a letter. Your parents, we've worked with parents who want to abandon their kids for becoming conscientious objectors. A letter from them has a lot of weight. A spouse. Letters of support are very important. So once the application goes in with whatever supporting documentation you have, then the applicant has a chaplain interview, and the chaplain is tasked with determining the depth of sincerity. The chaplain has to reflect back what is the nature of the belief that is causing this claim,
that is giving rise to this claim, and what is and a determination of sincerity. Do they believe this person is sincere? So the chaplain interview is very important. We like to do prep and some role play. There's a psych eval, pretty standard. The psych eval is meant to determine, could there be a different way, a medical channel through which this person could be discharged? So we don't have a CO on our books, a CO statistic on our books. Then there's a hearing in front of an investigating officer. Also, requires a lot of prep, the same kind of thing, some role plays, but the biggest source of preparation is going to be that application. As I mentioned before, as you're moving through the different drafts of the application, we want to make sure that there is not one question that the investigating officer or the chaplain is going to toss at this person that they have not already thought deeply about themselves through their own preparation. The investigating officer writes a report and makes a recommendation. And then depending on the branch, well, you always have a chance for rebuttal. We can always do a rebuttal. Sometimes that's substantive and, can be against the arguments the investigating officer is making. Sometimes it's just to correct some errors in the record. And then it starts to move forward. Depending on the branch, those steps could be very few before it gets to headquarters of the particular branch, or they could be, there could be several steps. But the decision for conscientious objector applications in every branch is made at the level of headquarters, the secretary or the commandant in the case of the Marine Corps. And in the Navy, in the Marine Corps, only the Secretary of the Navy can deny. So it's a very, very high level process, which is good and bad, and we can talk about. I don't want to go too much over here. But another thing that is quite important as it's moving through those steps is tracking it. As you're counseling someone, you want to make sure that they know they should have a point person who's tracking their application as it moves to headquarters and affirming once it gets to headquarters. And that's the process. And I'm going to leave it there for your questions after we hear from the other presenters.
Thank you, Maria. Just a quick note that our code for the first, to write down for those of you watching online, the code is F, the letter F, Foxtrot. So write that code down. You need that to claim your credit. And we'll have another code a little bit later on this hour. Our next speaker is going to be Deborah Karpatkin, and she has a slideshow. So let me cue that up real quick on the share screen, and then we'll hand it off to Deborah. If I can.
Great. Do you want to put it in podium view? Down at the bottom?
If I can figure out how to do that.
Okay.
You
Down there. I don't know if you can see my cursor. If you go to the bottom of the screen, right side, you see a thing that looks like a podium? One more, that one, yeah, click on that.
There we go.
Good. Okay, so welcome everyone. I pick up this story if, in the very rare circumstances that Maria and her colleagues are not successful in getting their CO applicant granted CO status. So the situation we're starting with is you get a call. Maybe it's from Maria, maybe it's from folks at the GI Rights Hotline saying, we have one for you. One of our people was turned down. We did everything right, but we're in a bad situation. So what do we do here? And the question is, you are a lawyer, you are somebody who maybe is thinking about representing military COs, but you haven't done it yet. And you want to know how to think about what you're going to say yes to Maria or whoever else who calls you.
Deborah, can I stop you for one moment real quick? I need to make someone else a co-host because I can't see when someone's joining the meeting.
Why don't you be a co-host and I'll run my own slides.
Okay, yeah, let's do that. Yeah, the problem is I don't want someone stuck in the waiting room. Okay, Deborah, you are now co-host, so you can share slides.
Okay. Okay, is everybody seeing the slides?
Not yet.
There we go.
Okay.
Now we can.
Okay, good. And I can run them. Excellent. Okay, so we've done that. So here, what are the first things you're going to do besides panic? There are three basic things that you're going to want to do. You're going to want to see and read the entire administrative record. You're going to want to talk to the CO counselor who worked with the CO applicant, if they did have one, and you're going to want to talk to the applicant themselves. So let's look at each of those things together. The administrative record is the pile of paper that Maria averted to before. It starts with the CO's application, which you will want to read really, really carefully. It includes any supporting material that was included with the application. It includes the report from the chaplain, from the psychologist, from the notes of the hearing, the decision of the hearing officer, and whatever happened after that. It's a lot of paper. Some of it is feels repetitive, but it is where the record of your case is if you are potentially heading to court. So it's really, really important for you to plunge in and get your arms around that. What are you looking for? You're looking for a sense of what your potential client looks like on paper. You want to see if they skipped any steps. It happens that there are procedural errors. You want to see if there are any factual gaps. Far less likely if the person came to you through one of the great counselors who work in this area, but not all of them do. And there may be gaps. There may be, the story may feel incomplete to you. There may be things that are missing. And then you're going to want to focus on what's not on paper to see whether you can reconstruct it. There was a hearing. That hearing no doubt influenced the investigating officer one way or another. Was there a transcript? Was it recorded? Was it, if it wasn't actually transcribed, was it summarized? If that summary was created by the hearing officer, is it accurate? Is it complete? Maybe if it was incomplete, the team working with your CO potential client put in the record where it was incomplete, but maybe they didn't. So that's more that you'll want to know. And the application and the administrative record will give you a sense of who your client's allies are and who isn't an ally for your client. Maybe their immediate command was an ally. Maybe they said, yeah, this guy should be let out. Maybe coworkers, other military people said, yes, this guy is sincere. I don't agree with him, but he's sincere. Or maybe there is evident hostility from some of the papers in the administrative record. You're going to want to focus on all of that. The next thing you're going to want to extract from that is to figure out why they said no to your guy. The legal standard, as Peter's going to talk about, is basis in fact. And the sad news is that almost anything can be a basis in fact. Almost anything. And we're not dealing with a preponderance of the evidence standard here. If we're going to challenge a basis in fact, it needs to be clear and convincing evidence. Peter will probably talk about that a bit also. But the guts of it is likely to be that whoever was the decision maker, the early decision maker or later decision maker, didn't think that your potential client's views were sincere or deeply held enough. Maybe they waited too long to identify themselves as a CO, or maybe they didn't wait long enough. Maybe they're not religious enough, or maybe they're not religious-like enough, or maybe their religious beliefs don't align with the decision maker's view of what that religion says about participation in war in any form. Maybe they were seen as too shallow, or maybe the papers were that their beliefs developed too late in the process, not when they applied, but when they should have been recognized their own beliefs. Sometimes you see that there is hostility in the hearing officer or in somebody else in the decision-making tree to what your client's asserted religious, moral, or ethical basis for their CO beliefs are. And we see that when the beliefs are not mainstream religious, but we also see them in spaces where they are mainstream religious, but interpreted differently from the views of the hearing officer. We see this in Christianity, where many hearing officers consider themselves, and decision makers consider themselves, mainstream, devout, believing Christians, and they find it really hard to believe that somebody else who is the same as them could believe this. It's very destabilizing for them. And then the last, and that goes to Maria's evidence questions, what are the actions that shows your client's commitment to their asserted beliefs, and is there enough weight to those? So you'll find those sorts of things flagged as evidence as the support for the basis in fact for saying no. And you'll be wanting to read carefully for those as you go through the decision-making process. The next thing you're going to want to do after you have gotten to know your client a bit on paper is to understand who your client is as a person. They enlisted. Why did they enlist? How old were they when they enlisted? How much education did they have when they enlisted? What are their oral communication skills like now? And how well do they communicate in writing? How much work experience do they have besides their job in the military? And how sophisticated are they? I've had clients who enlisted straight from high school who were indifferent students, and I've had clients who went through advanced graduate school training and the military academies. There is a range, and part of effective representation is knowing where your client is, those kind of demographic facts. It's really important to spend time with your client in person, because you are going to be with this person and getting into their head and getting into their beliefs in order to advise them on their post-CO legal and strategic options. So the idea of crystallization, how did their beliefs evolve and why and when, is a hard question for some people. As Maria said, they know the moment. I've had clients who've known the moment for reasons other than Maria said. It was somebody who I had a client who believed that he couldn't kill other people who hadn't been saved yet because of his Christian beliefs. So it was okay to kill people who had been saved, but not non-Christians who hadn't been saved yet. I've had clients who believed that they were making a career in the military until they were asked the question whether they could detonate a nuclear warhead. And then they suddenly realized they couldn't do it, and then tried to talk themselves out of being a CO because they didn't want that outcome. So there is a range of crystallization. It's not always a road to Damascus sudden moment. You want to know who is in your client support network. Who's on their side? Who's on their side where they physically are now? Who's on their side in their larger world? Do they have a support network? How is their health? How's their physical health? How's their mental health? Where are they stationed right now? And are any transfers or deployments coming up anytime soon? That's going to go to the venue question of where you can file your CO application. You're going to want to know how they're being treated now that their application was denied, and how they were being treated while their CO application was pending. What are their duty assignments? Were they assigned duty that they could functionally comply with, that didn't too much conflict with their asserted beliefs? And has that changed now that that's denied? That will give you some sense of the stresses on your client and the urgency of the work that may be before you. I think we did this. You're going to be looking at, now that you know your client in person and now that you've studied the record, you're going to now try to put that together and see what the record shows about your client and whether it's a full enough picture, and you'll see where there are opportunities possibly to develop it. This is particularly so for somebody who did not identify as a religious, as in their beliefs being religiously based, because maybe there are ways to amplify that going forward, and we'll talk about that next. So if there isn't a timeline in the materials already, then creating a timeline could be a really important document, partly for you and partly for the court if you can figure out a way to get it included in the record, which we're going to talk about. If the basis for beliefs was stated non-religious, maybe your client isn't describing themselves as accurately as they could. I've had clients who said, I'm not a religious CO, and I read their papers and I talked to faith leaders and said, read this, do you think this is faith-based? And they said, yes. Had clients who say, I couldn't say I was faith-based because I don't go to church. Well, that's not an answer to the question. Why this matters is that, notwithstanding what the law says about ethical and moral beliefs, religiously based beliefs are sometimes easier for skeptics to understand. So if that factual opportunity exists for you, you will want to identify and potentially build up on it. You'll want to know how your client is doing right now. How is their mental health? How is their physical health? Are they getting any spiritual support if that's of meaning to them? How isolated are they? We talked about their duty assignments. Do they have a security status, and has that been changed? What is their risk of deployment? Are they being harassed? And should you be considering an Article 138 to address harassment? And always, is there a potential UCMJ risk here? And as a lawyer, you will have to counsel your client if they are thinking about leaving because they can't cope. The reason knowing all this stuff matters about how they're doing and their duty assignments and the status of any security clearance is there may be other ways to get out. If their medical or physical, if their physical or mental health has deteriorated a lot, then that could be a basis for discharge. This is challenging for many service members, particularly young men who may not be comfortable saying how they feel or showing how they feel. And you're going to have to support them and elicit this. This is not the same question as Maria was asking about what's changed in your life. This is about how they're doing right now, now that they've been denied. What are their changes? Sleeping, eating, mood, energy. I've had clients who were incredibly optimistic about the possibility of granting CO status. They totally believed that the service that they had joined that was fair and honorable and decent, all that good stuff, was going to read their papers and believe in them. And then it's a huge crash for them when they're told no. You need to, this is stuff that you'll want to elicit. You maybe have an opportunity for getting out, your client getting out for medical reasons, for behavioral reasons, for the good of the service. Sometimes there is a UCMJ way of getting out. That may not be every client's choice, but I have had clients go that way. Now, why might these other avenues be available? The statistics that are publicly available on how many COs are granted are not that accurate in terms of who gets out because they are a CO. And people are COs and they get out without a CO discharge, and those people exist. So one of the things that you may have seen in your study of the file and you're learning about your client is that maybe there's a new and different opportunity for a new and different application, a new application based on new and different evidence that is available to you in the Army regs, and I'm not sure about the other service regs, but it's a very important opportunity to consider. And why is because it gives you a second chance to possibly get out as a CO, a second chance possibly to be assigned to non-conflicting duty, and most importantly, even if it's a total fail, a chance to add to the administrative record with more clergy support and more witness support and more evidence of continued adherence to CO beliefs. So when you're thinking about the pre-lawyering part of CO, this is a potentially big opportunity for you. Sometimes these cases are best litigated with a partner. And I have litigated, I think, almost all my CO cases with an ACLU partner. That is for me, it has been a good way to go, and it may be true for others as well. That comes with some concerns. First, your client has to be comfortable with that relationship. Your client has to be ready for the publicity that will follow from being a client of the ACLU. And what could follow from that is nasty comments in the press, in chat and so forth. It can be very hard for people to deal with. My advice to folks is that if you're doing this, to make sure that's in your engagement letter so that you know that they've counseled for them. One of the reasons that we look at the how your client is doing right now is that it might give you the basis for a TRO or preliminary injunction. And I don't know, Peter's going to plan to talk about this, but you're helping to develop the record here. You want to see what you can do to document your client's failing physical or mental health, document command hostility or threats, other safety concerns, and it's a chance also for you to build up the factual basis for likelihood of success. Maybe you have clergy affidavits, maybe you have affidavits from more than were in original record from family, friends, coaches, teachers, folks who play that kind of role in the community and carry, because of their status, carry more weight and credibility. You want to, as you are preparing for court, you'll want to see what's in your administrative record. You'll want to think about venue. where is your client now and where will your client be in the near future? Peter may talk about where you can bring these cases and where your strategic options there. Bear in mind also that the lawyer that maybe was following your client's CO packet while they were in application status will not be the same lawyer who is opposing you in court if you file in court. Now, they may be supported by them. There may be former military or active duty military lawyers working with the Assistant U.S. Attorney's Office, but not the same person. And there are lots of ways to win for a CO client. Getting out as a CO, sure. Getting out for health reasons, sure. Getting out for administrative reasons, sure. Getting out for any reason is a win. And the other reasons don't necessarily come with the financial penalty of paying back for your education if you're a CO, just saying. So why should you take on one of these cases? They're very challenging. Challenge is good. The challenges can be supported by support from colleagues. Getting somebody out of a job that they can't do because of their conscience is an incredibly powerful feeling as a lawyer. You really feel like you've done something that makes a big difference in people's lives. And while it's very, very rare, in theory, at least, you can collect fees and expenses if the government's under the EHAA, if the government's position is not substantially justified. And that's what I have. And I guess I turn it over to Peter now.
Yes, before we go on, I do want to mention our second code for this session. And so if you're watching online, please, and you're needing CLE credit as an attorney, be sure and write down the code T. T for Tango is your code, the second code for this hour session. So now we'll hand it off to Peter. I will mention just one brief thing. We're running a little bit behind, so we'll probably cut into the break a little bit, give Peter some more time. And then after that, we'll hopefully have a very short break, and then we'll move into our next sessions at the top of the hour. I'll also mention that because we probably will not have extended amount of time for Q&A, I will be sharing the questions that have been posted in the chat with the presenters. They may be back in touch with you with some responses on the questions, but you're also, if they want to answer in the chat later on, that's fine too. So Peter, go for it.
Okay, well, I will actually try to make my presentation shorter instead of longer. Because there's an enormous amount of overlap between what Maria said at the beginning, what Deborah just said, and what I was going to talk about, because these are not really three separate topics of the counseling process. While the initial counseling process that Maria talked about, the considerations of what a lawyer can do if the applicant is turned down without suing in court, and what one does if you eventually decide to go to court, because they're all interrelated questions. I want to highlight that in the materials online, in the what was already posted, and which I encourage you to go to, I have submitted a 3.5-page single-space detailed outline that covers the technical questions related to going to court, but also some of the non-court aspects that Maria has already talked about. And so rather than rattle off a lot of citations and every technicality, I'm going to highlight the main concepts, I hope, and encourage you, if you are interested in learning more about this, to go to the written outline that's in the materials. So in the event that someone applies for a conscientious objector discharge and is turned down, there is a right, long established, going back into at least the 1950s, recognized by the Supreme Court, to file a case in federal court, in civilian court, to challenge the outcome. And that case is framed as a petition for habeas corpus. The reason is that it's considered to be a form of being in custody to be in the military, because you do not have the right to make your own decisions of where and when you will come and go or walk away. So in that sense, it's analogous to being in prison. and habeas corpus is the mechanism. That has its pros and cons. Habeas corpus is a flexible remedy, doesn't have a lot of strict procedural rules that apply to it. On the other hand, it's a limited remedy, and it's used for later court review of decisions, be they decisions of other courts or of administrative agencies, or in this case, the military branches, that are subject to minimal civilian court oversight. And that's the heart of the habeas process. So I want to be principally focusing on the fact that winning a habeas corpus petition in court on the merits is extremely rare and difficult, but it provides an opportunity to further assist the client who is the wrongly denied conscientious objector in the ways that Deborah has already pointed to, by bringing in another kind of federal lawyer on the other side, a civilian, by having a decision maker who is not in the military, although is likely to be very deferential to the military, and by creating a risk of setting a precedent that the military doesn't want set in the form of a written decision if you have a chance to prevail. So the habeas corpus petition is a fairly simple federal complaint. Anyone who is a lawyer and has brought a civil rights complaint or an ordinary civil complaint of habeas petition doesn't look any different from that. It's not subject to the forms and complicated rules that have been added to habeas corpus proceedings for state criminal prisoners going to federal court under 28 U.S.C. 2254, which is the most common form of habeas corpus in federal court. It's not subject to those rules. The habeas petition has to be filed in the federal district where the immediate commanding officer is located if the person is subject to orders of a commander, which most of our clients are. And so there's a strict and limited rule for venue. And what's more important is the scope of review. And that's what I'm going to try to spend my time on for the next maybe 5 minutes. And this reflects back again to things you've already heard. So what the Supreme Court declared in the 50s when it first heard these cases, and the cases that it first heard were cases of Jehovah's Witnesses who had been refused draft exemption, were brought into the military and then refused to cooperate in the military. And so they had habeas review of the denial of military orders in the military. And in those cases, the Supreme Court established this very deferential standard of review called basis in fact that Deborah already alluded to. But basis for what, in fact, is the important thing. That is, the federal judge is obligated to deny the petition if there is a basis in fact for the reason given by the secretary of the service branch for denying the petition, not if there is a basis in fact for denying the petition on any grounds. So on the one hand, review is limited in a favorable way. That is, it's limited to review of the reason that was given, and there is an obligation to give a reason. You don't get a summary denial, you get a denial for a reason. And the reason has to relate to one of the criteria for qualifying as a conscientious objector, the criteria that Maria referred to. That is the person reason for wanting out not conscientious? That is it insincere? Is it an objection to something other than to personal participation in war in any form? And I will refer back to our friend Muhammad Ali, who was quoted earlier. His case in the Supreme Court, Clay versus United States, made clear that being a professional boxer who makes his living beating other people up does not mean he is not a conscientious objector to participating in war, nor the fact that his religious objection as a Muslim did not preclude the idea of participating in an end times war of good against evil, in a Quranic or biblical sense, a hypothetical religious. Was the reason for denial that the belief was said to be something other than religious? Was it claimed to be merely philosophical, or a merely personal moral code, or some other catchphrase that's used in this body of authority for not religious? And can that be attacked and shown to lack a basis in fact by reference to the broad definition of religion that was developed in the draft cases in the 70s? Is the belief said to have pre-existed the person's enlistment, which is a disqualifying? That is, their beliefs crystallized too early, according to the service branch. And is there a basis in fact for that? That's also sometimes a fertile ground, because beliefs don't often occur all at once in 180-degree reversal. They develop. So an argument about when the development reached the point of qualifying can be fertile grounds. The other category of issue that can be raised in court is procedural. So those were the substantive grounds. Is there a basis in fact for the reason that was given? But also procedural grounds. Again, we referred to this earlier. Did the military branch fail to follow all of the complicated steps that are set out in the service branch regulation for processing a CO application? And if they failed to follow the steps, and if the failure to follow the steps may have resulted in the wrong, an incomplete reasoning of the decision or a wrong decision, that's a ground to overturn the decision as well. And I will say that's the ground on which Muhammad Ali won in the Supreme Court, was a procedural violation in the end, even though they commented that his beliefs were qualifying, not disqualifying, as had been thought. The grounds, the relief that the judge can give in a habeas if you prevail is very favorable. The habeas corpus it's not it doesn't get sent back to the military for a new decision. Ordinarily, it's decided on the merits, and the decision by the judge can be to order a discharge on honorable grounds with full veterans benefits. It can be the vacating of a court-martial conviction if the grounds for, say, refusing an order were related to the improperly denied conscientious objector application. And these were all decided, the points I just made are decided in various Supreme Court cases in the 70s. The only other thing I will say, again, is just to echo what Deborah already talked about, is after filing, you've put pressure on the other side to settle the case like any other basically civil case in court, and the settlement can be something that looks like short of a full win. It can be for a discharge for the convenience of the service, for a discharge on medical grounds, for a remand, so to speak, if that's going to get a favorable decision by agreement or something like that. So going to court can be a mechanical opportunity to prevail. Cases that go to the merits, though, I've listed at the end of my outline all the cases that have gone up on appeal in the last 15 years to the federal appeals courts, not all the trial court level, but all the appellate decisions. And the great majority of them are losses and reviews of losses. So going to the merits in court is not your most likely ground for success. I do need to say one thing, which is that these criteria the narrowly defined criteria that Maria referred to in the service branch regulations may be invalid. And that's because in the last few years, as all of us know, the Supreme Court's view of religious freedom has greatly expanded as a result of pressure from conservative religious groups on abortion issues, on vaccine issues, on school issues, public school issues, all sorts of things, ostensibly unrelated to conscientious objection. But the precedents that were set, both under the statute, the Religious Freedom Restoration Act, and under the First Amendment, cast very serious doubt on the validity and viability, if those principles were to be applied in a neutral and objective way to military conscious objectors, very serious doubt on the viability of all the precedents that were set from the 50s to the 70s, both enforcing the specific and mechanical grounds for conscientious objection. So we don't have time this morning to talk about that, but it's outlined in detail by Deborah and me in an article that was published in On Watch, that's in the materials in the folder, and summarized in my outline that I referred to earlier. Let me leave it there for questions, or in James' discretion, whether it's time for the break.
I'll just mention briefly that we'll be starting our next session at 10 a.m. I will be gone for about 3-4 minutes to grab a jacket. This room is very cold we're in right now. So if you do have any questions, feel free, and we'll be back in about 4 minutes with our next session.
Deborah, did I misstate anything that I ought to correct in the chat?
No, I don't think so. I think that there are a couple of favorable decisions.
Yeah,
The Hannah case in our jurisdiction, Second Circuit, yay, Second Circuit.
I think I got them all in the list, but
it's not a total fail. Unfortunately, a lot of the context of beliefs affects outcome because RFRA hasn't caught up to the CO regs. So selective conscientious objection, which is unfortunately a total fail legally, is an easy trap for somebody who says my views crystallized with this war, that war, or the other war, because it feels selective at the time. Muhammad Ali was successful, but nobody really examined what happened. But it's not helpful in terms of doctrinally for the people who identified themselves COs at the first Gulf conflict and the second saying, I am opposed because of my religious belief to war against other Muslims. That was labeled as CO, as non-CO, as selective, and therefore was a fail. But maybe under RFRA, it would not be.
Selective, the exclusion of selective objection under the draft law and under the CO, military CO rec is absolutely inconsistent with RFRA. Absolutely would be struck down if that law was applied neutrally to these cases. What we don't know is if it will be applied neutrally.
So there would be a mass exodus from the military, excuse me.
Yeah.
And the only other thing I want to add is, as Maria stressed, the importance of it being about...
Let me say, Maria, by the way, that's actually not supposed to count under RFRA. I mean, the RFRA cases even take that into account because the burden is not on according to the RFRA cases, is not on the system, but on the individual. That is to be looked at. And it's looked at, could the system survive letting this person out? Is the RFRA question, where the Supreme Court looked in Gillette at the question of could the military survive letting all of these people out? Right?
So the point I want to go back to,
totally inconsistent approach,
is about opposition to the individual's participation in war in any form. One of my favorite stories, which goes back to a long time ago, is about a Navajo man who whose tribe was a war, whose tribe believed in war. But he one day became identified as a healer. And the traditions of the tribe were such that he, as a healer, could not participate in war in any form. And his claim was a successful CO claim. That was in the earlier stages of CCW. If I can find a link for it, I'll put it in the chat. But it's a really good illustration of what that phrase means and
it's not judging your religious group; it's judging you.
Yes.
I had
that's absolutely true of Jewish objectors for sure, across the board.
I worked with a physician who was in the Air Force for 11 years and then was tasked with deployment. And she realized she had never thought about it before. She was an oncologist. And once she was tasked for deployment and had to begin training with a weapon and doing, you know, role playing and war games, she realized she had become a healer, although she didn't question the legitimacy of war or, you know, support for war as a physician, patching people up in order to go kill other people. She herself that was not what she was able to do anymore at this point in her life. She was actually stripped of her command during her process. She was 1AO, so she chose to stay in. And then she fought when she was approved, she fought and got her command back.
Did she have to pay back?
She stayed in. She was a 1AO.
Oh, okay.
Yeah. She would have had to pay back. She was in the Air Force. I've seen a 100% recoupment from the Air Force.
Yeah.
Well, we're now ready to start our second session. And let me get the mic set up for this one because I'm actually one of the trainers.
I'm going to say goodbye to everyone. I have another meeting I have to get ready for. Wonderful to be with all of you. Wonderful, Peter and Maria, to present with you, and have a wonderful rest of your CLE program.
Thank you.
Thank you. Thank you.
Bye.
Take care, everyone.